Hello, everyone. This is my week 8 presentation discussing employee privacy, the public's right to know. And we'll get this started. I'm going to take this a little bit to the left and talk about the video and how employers can track employee cell phones in some instances, but also talk about other cases that are similar but slightly different. So, here we're discussing how to balance privacy and public interest. On one hand, if you're working for a public agency, transparency is of the utmost importance. You're dealing with public funds. Thanks to marbling, you have a mixture of local municipal funding mixed in with federal funding. So you have a lot of interested parties and stakeholders in play. Meanwhile, you still have people with constitutional rights carrying out the duties. And the mixture of the rights of the taxpayers and the rights of the employees is what gives us issues. So one such example, I'm going to take it a little bit to the left, is the Public Records Act and Bring Your Own Device. So some public agencies subsidize or allow employees to bring their own cell phone device to conduct work-related business. The issue with that is, as soon as a government entity subsidizes or pays for a portion of that phone then becomes theirs to some measure. Or as soon as a public employee does work-related business for a public entity, that work, that product, those documents, those text messages, those photos become property of that government agency, which means that it becomes a public record. So those phones then become subject to discovery or search. If there's a public records request asking for text messages between that employee and such regarding a particular project, that phone must be searched. And that doesn't mean all text messages are produced to the person making the public records request, but they are subject to search, and then the relevant text messages will be pulled out. There's a case law. We had the City of Ontario versus Kwan a few years ago, and Officer Kwan, I believe, was saying that his employer cannot search his phone, but they were saying that they didn't go and they redacted all the personal information. The text messages that they pulled were specific to a certain investigation that it was necessary. And another case law we have is Carter versus County of Los Angeles a couple years ago, where the County of LA was suspecting that their dispatchers were doing some non-work related activities in the dispatch room. So they installed covert cameras and found that their suspicions were justified. They also found that other employees that they were not originally investigating were doing some things, wasting time on the clock. The issue with that was that in this case, this dispatch room was it gave the employees expectation of reasonable privacy. So typically, these employees were the only one in that particular room. It was under card key access. It was locked. No one else really had access to it except for that one employee during their shift. And because of the nature of the work, these employees never really left that room. So they took their breaks in that room. They had equipment to cook meals and sleep in that room. So because they were working in that room, but there was enough time and facilities in that room that made it more like a break room or a private space, the courts ruled that it violated the employee's Fourth Amendment by installing this camera and spying on the employees without their knowledge. And that brings up an interesting subject in these cases of employer right to know and employee privacy and transparency is the Fourth Amendment. So the Fourth Amendment applies to government's unreasonable search of us. And when you work for the public sector, you're essentially working for a government entity, and you're then protected by the Fourth Amendment. So now you have this conundrum where you have cases such as the one where the teacher's Facebook was subjected to discovery and she was fired for the content she posted. But then you have other instances like the county of LA, where they implemented the Fourth Amendment protections in saying that a government entity has no business searching or spying on an employee without reasonable cause or warrant. Very interesting. Uh, so final thoughts is just, as a public employee, just remember that anything you say or do, even if it's on your own private device, if you're conducting public agency business on it, it is subject to discovery, and courts will rule that public disclosure may override right to privacy in those cases. However, we do have Fourth Amendment protections in working for the government and saying that the government cannot conduct unreasonable searches of us or covertly spy on us. Again, that case where the lady's Facebook page was used to fire her, that was in the state of Georgia. I don't know how Georgia's constitution protects them over there, but that's just what we have out here in California. So thank you for this presentation. If you want my personal information, I've redacted, hidden, made it private, and encrypted it. So good luck finding it. All right, take care.